All right. Well, I'm really excited to be able to welcome back Ken Stahl from Miller Star Regalia and a law professor at Chapman Law School for an update on our previous presentation on the Builder's Remedy in Orange County. I will say that this issue is ever evolving, and I have even heard just as soon as yesterday from somebody with a project in a city that will remain nameless for the moment, where they've been working on the project for 3 years. They had not been able to get the city to process it, despite repeated attempts to get in front of electeds. It didn't happen. They are a city that's currently being sued by a housing advocacy organization for being out of compliance, their housing element being out of compliance. And I got a phone call that this developer representative met with the city staff and said, basically, look, we haven't been able to get here any other way. But they had developed a rapport, so he didn't ruin the relationship. He was actually able to speak with the director, who said, listen, we get it. And then, don't you know, on the drive home, I believe, he got a call from the elected official who he had been trying to reach for months. I mean, months and months. And I can say that because I was a connection and had tried to help him get that meeting. So it is a tool in your toolbox, and I will stop there and let Ken get started. So thank you very much, everyone, for joining us, and I hope that you find this useful and helpful.
Well, thank you, Liz. It is a delight to be back here with my friends at People for Housing Orange County. I kind of launched this presentation on the Builder's Remedy a few months ago at Liz's invitation. And since then, I've had the chance to do it a number of times to different groups. And I've always been really impressed with the feedback and the interest. So I've always been happy to reprise it. So for those of you who've attended this presentation before, thanks. I'm glad to see you back again. I'm hopeful that I can provide some updates. As you see here, I'll frequently note when there are some updates to be given. But even where I'm going to be treading old ground, I think it will still be useful because some of this stuff is so complicated. So happy to have those of you who are back, and also those of you who are new. I'll try to recap the basics so that there won't be any need for you to have seen the previous presentation for this to make sense. Here's a little bit about myself. For those of you who hadn't been able to attend the previous presentations, I am a law professor at Chapman University and run the program in environmental land use and real estate law. I'm also a land use attorney with Miller Star and Regalia, and in that capacity, I've had a lot of experience dealing with state housing law, particularly the Housing Accountability Act, which is the law that we're talking about today, the thing that's known as the Builder's Remedy as part of the Housing Accountability Act. And I've also been working with People for Housing for a number of years. When I did this presentation in the past, and you'll hear this again today, I frequently throughout the presentation talk about how many unanswered questions there are about the Builder's Remedy. As we'll discuss, Builder's Remedy, although it's been around for a while, has not really been used very much until very, very recently. And there are some ambiguities in the statutory language. And so what that means is that there are a lot of unanswered questions about the application of the law in practice. Many of those questions haven't been answered and may only be answered either through clarifications by the legislature, clarifications by the state's Department of Housing and Community Development, or through litigation, which can take quite a while. Now, we don't have many of those answers yet, but we're starting to see some tea leaves in the time since I gave this presentation last. And so it's reading those tea leaves that I'm going to kind of focus on in terms of the update. And of course, I'm happy to take anyone's questions. You can just drop them in the chat or raise them after the presentation. Takeaways, again, nothing here is going to be new from last time, but many cities in the county and throughout the state are out of compliance with state housing law. And that means they face a potential penalty called the builder's remedy. The builder's remedy means that a jurisdiction that is subject to it, and I'll describe what that means, potentially must approve any housing development project with at least 20% lower income or 100% moderate income housing on almost any site in the jurisdiction, regardless of the locality's general plan and zoning standards. So it's been referred to as kind of a zoning holiday, where you have the ability to sort of throw out any general plan and zoning standards that you don't like. You could also think of it as like a super density bonus law. A density bonus allows you to kind of waive away certain standards, but only if you provide a specific level of affordability. Builder's remedy law allows you to throw out even more general plan and zoning standards, with, in some cases, even less affordable housing being required. The builder's remedy, though, does present, I think, a great opportunity in some ways, and Liz already alluded to some of the great opportunities that the law presents, but there are also some risks. The risks are primarily, as I just alluded to, there's a lot of unanswered questions still. So we don't know exactly how the builder's remedy law is going to be applied in practice, but we have some ideas. And I think developers, as well as land use attorneys and advocates, activists, legislators, are all going to play a role in shaping the way the builder's remedy is going to be applied. It's not a passive thing where we're all just going to wait and see what happens. There's a role, I think, for all of us to play in shaping how the builder's remedy plays out. Okay, so standard caveat here. The presentation is not legal advice. I very much encourage you to consult with a land use attorney before pursuing a builder's remedy project. I can really only talk at the high level here about the law. I can't talk about specific projects or project sites in this presentation, but I'm happy to speak with anyone if you want to talk about more specifics afterwards. Here's kind of the agenda of the different things we'll be talking about, and then I'll go right into it. Builder's remedy basics. Okay, so I mentioned earlier, every local jurisdiction that exercises land use authority in the state of California is required to have a housing element in its general plan that accommodates its fair share of the regional housing need. And that housing element must be updated every 8 years, and submitted to the state's Department of Housing and Community Development for approval. So I have just summarized in like 10 seconds an incredibly complicated and lengthy process, but that's the basics of it. Every city has to do this, and county, every 8 years. And then HCD signs off on whether that housing element is compliant. In other words, have you reasonably accommodated your fair share of the regional housing need in your housing element? Well, most jurisdictions don't want to have to reasonably accommodate their fair share of their regional housing need. And so to date, most jurisdictions in the state, and certainly most jurisdictions in Orange County, do not have compliant housing elements according to HCD. And it is that determination by HCD that a jurisdiction does not have a compliant housing element that potentially triggers this builder's remedy. Before I get into the statute and how the builder's remedy is triggered, I just want to show you this very important chart. HCD maintains on its website a live report of the compliance status of every jurisdiction in the state. You can find the report at the page listed at the very bottom of this slide. And all of these slides will be available on the People for Housing website. So you'll be able to find it and click on the report right from there. But here we have a screenshot from this compliance report. This is not a live update. This is a screenshot. So you'd want to make sure you check the actual live status by clicking on the link. But the key statistic here is this very last column where you see compliance status. If a jurisdiction's compliance status is listed here as out, and you can see at least on this page, the last I checked, every jurisdiction on this page was out of compliance. And footnote, I doubt very highly that Huntington Beach is in compliance since the last time I ran this check. If a jurisdiction is out of compliance with state housing law, according to HCD, it will be listed here. And once you look at this chart and see that a jurisdiction is out of compliance according to HCD, then you know, aha, this potentially is a jurisdiction where the builder's remedy may be viable. If HCD has listed the jurisdiction as in compliance, then, such as Irvine here, then it's probably not going to be the ideal circumstance for using the builder's remedy. Okay, so now let's put all the pieces together and talk a little bit about the builder's remedy statute. So the builder's remedy is a name given to a part of a stellate called the Housing Accountability Act, a law that has been made very potent in recent years. It is subdivision D of the law that contains the builder's remedy. So I'm just going to walk a little bit through the statutory language because I think this is somewhat illuminating. It says here that a local agency shall not disapprove a housing development project with at least 20% lower income or 100% moderate income housing, or condition the approval in a manner that renders the housing development infeasible, unless the jurisdiction makes written findings based upon a preponderance of the evidence as to one of the following. And then there are a list of 5 situations in which a municipality can deny a project containing 20% lower income or 100% moderate income housing. I'll just pause here just to note something for emphasis. The underlying language, preponderance of the evidence in the record, is a legal term of art that is quite significant. Traditionally, courts have given a great deal of deference to municipal determinations about a project and their decisions whether to approve or deny or condition a project. And any of you who've ever had to litigate against the city probably have had the unhappy experience of knowing how much deference courts traditionally give to local governments. One of the sort of revolutionary aspects of the Housing Accountability Act is that it flips that deference and orders courts to give much less deference to local government determinations. Specifically, this is not the only place in the HAA, but it's one of them, where the statute requires courts to apply a standard of review called preponderance of the evidence. That means that the local government must prove that one of the following 5 conditions is met more likely than not. It's not enough for the local jurisdiction to just say, well, we think one of these conditions is met, or we found it. They have to prove it's more likely than not, based on written findings, that one of these conditions is met. So it makes it a more difficult standard for local governments to meet than they're traditionally accustomed to. Okay, now most of the conditions under which a municipality can deny a project are pretty narrow. The one that is most likely to be relied upon is the 5th one, which says, as you see here, the housing development project is inconsistent with both the jurisdiction zoning ordinance and general plan land use designation as it existed on the date the application was deemed complete. And the jurisdiction has adopted a revised housing element in accordance with state housing law that is in substantial compliance with this article. Okay, so what does all this mean? In order for a local government to deny a housing project with 20% lower income or 100% moderate income housing, the local government must find, by a preponderance of the evidence that is more likely than not, that the project is inconsistent with the local government's zoning and general plan, and that the local government has a housing element that is substantially compliant with state housing law. Okay, so what this tells us when you pull the pieces apart is that even if a project is inconsistent with a local government's zoning and general plan standards, the local government still cannot deny the project if the local government does not have a housing element that is substantially compliant with state housing law. That is the builder's remedy. The local government cannot deny your housing project, even if your project is inconsistent with the zoning and plan standards, if the jurisdiction doesn't have a substantially compliant housing element, right? And that's my summary here on this next slide. The jurisdiction does not have a substantially compliant housing element It may not deny a housing project with at least 20% lower income or 100% moderate income units, or condition it in a manner that renders it infeasible, even if the project is inconsistent with the development standards in the general plan and the zoning ordinance. And again, it's the local government that has to prove, more likely than not, that it has a substantially compliant housing element and that your project is inconsistent with the zoning and general plan standards. So that's the kind of basic summary of what the builder's remedy says. Okay. So how do we use builder's remedy in practice? Well, as I've said, you're going to want to look at that chart from HCD, because one of the preconditions for using builder's remedy is going to be, does the jurisdiction have a substantially compliant housing element or not? Okay. Now this slide is definitely the cause of some confusion in previous versions of this presentation. So I'm hopeful I can sort out some of that. So starting at the top here, in terms of evaluating sites where the builder's remedy might be useful, you want to target cities that, of course, are out of compliance, but also ideally that do not have housing elements currently under review by HCD. Here's why. The statutory language I just quoted to you says that a jurisdiction housing element needs to be substantially compliant with state housing law, right? Substantially compliant, for the lawyers out there, does not necessarily mean the same thing as fully compliant. It just means substantially, close enough to being compliant. Now, how do we determine if a jurisdiction's housing element is substantially compliant? Well, of course, one way is if HCD has determined the housing element to be compliant. But another way is, suppose the jurisdiction adopts a housing element and then submits it to HCD for review. And then 2 months later, HCD says, yes, we agree, this is a compliant housing element. The question is, was that jurisdiction's housing element compliant when they originally submitted it to HCD? Well, I think the sort of better argument would be the jurisdiction's housing element was substantially compliant when it submitted that housing element to HCD. Not right, it may not have been formally compliant until HCD certified it as compliant, but it was substantially compliant when it was submitted to HCD. So what that means is, to be on the safe side, you probably want to look for jurisdictions that are out of compliance, but also do not currently have their housing elements being reviewed by HCD. The best case scenario is cities that have not even yet adopted a housing element, because it's really, really hard for a jurisdiction to argue that it has adopted a substantially compliant housing element if it has not even adopted a housing element. So if you look at this chart here, your best case is where the jurisdiction has not adopted a housing element. Once the city adopts the housing element, the argument becomes a little bit weaker, but you're in this arguable zone. But if it's been adopted, but HCD rejects the housing element, then you've probably got a pretty good argument that it's not substantially compliant. If the city adopts it, and then, as you see here, HCD certifies the housing element as compliant with state law, then you're in this difficult zone. So look for cities that are out of compliance and that do not currently have their housing elements being reviewed. And also look for cities that are likely to be out of compliance for a few months. That should probably be done in consultation with a land use attorney. But if you're looking at the state of the city's housing elements, are they working towards revising the housing elements? How are they holding meetings? How likely is it that they're going to be resubmitting something to HCD in the near future? You want to be thinking about that, because again, once they submit something to HCD, then you're kind of crossing your fingers for the next couple of months that HCD isn't going to come back and find them in compliance. Update on this point. One of the questions that has been out there about the builder's remedy is the effect of HCD's certification. Remember that I said that a housing element doesn't have to be compliant to satisfy the builder's remedy statute. It only has to be substantially compliant. What does substantially compliant mean? And is HCD the ultimate arbiter of what substantially compliant means? Or do the courts determine that for themselves? So for example, if HCD says that a housing element is not compliant, can a jurisdiction still argue that its housing element is substantially compliant? This is a tactic that some jurisdictions have tried, self-certifying their housing element. Say, well, we've certified that our housing element is compliant, and we think that's close enough. There is a thought out there that this could be a tactic that cities would try, and some cities have tried it. There is now, this is part of the update, at least an indication that the self-certification tactic is not very likely to succeed. The reason is we just got a decision from an appellate court in the case of Martinez versus the city of Clovis just a couple of days ago, in which the court strongly implied, this is not a summary, here again, we're reading tea leaves here. The court strongly implied, but didn't quite directly hold, that it's going to give quite a lot of deference to HCD's determination as to housing element compliance. And so if HCD determines someone's housing element isn't compliant, it's going to be difficult for the jurisdiction to self-certify in contradiction to HCD's determination. The converse, of course, is that if HCD determines a housing element is compliant, it's going to be difficult for developers to argue that it's not. So again, this is a case where you want to look for jurisdictions that are out of compliance and that are, according to HCD, and are likely to continue to be out of compliance, at least for a few months. And I'll explain why the few month standard is significant. But that's one update, is that it's possible we're going to see the courts giving more deference to HCD. And that gives a little bit more certainty that if you see the out of compliance on HCD's website, that the courts are likely to defer to that. Okay, so now this is coming to why you want to find jurisdictions that are out of compliance for the next few months. This has to do with timing and the application process. Okay, so there is a law that was passed a few years ago by the legislature called SB 330 that permits applicants to file what's called a preliminary application with relatively minimal information that freezes the jurisdiction's development standards in place. What this means is, if an applicant files the SB 330 application, the jurisdiction cannot change the applicable zoning rules on the applicant after that date. This is what's often referred to as vested rights or early vested rights. In California, absent SB 330, it's very, very difficult for a developer to get vested rights. The jurisdiction is usually free to change the zoning rules, even after you've submitted an application, even after you've gotten an approved entitlement. But SB 330 gives very, very early vested rights. As long as you submit this preliminary application, it freezes the jurisdiction's zoning standards in place at that time. And furthermore, unlike a lot of the game playing that you see with the Permit Streamlining Act in California, there's no real role for local governments to tell an applicant what has to be in that application and whether the application is complete or not. State law says, provide this list of things, and once you've done it, it freezes the standards. And there is no role for local governments to weigh in on whether the application is complete or not. So this is potentially a powerful tool. You file this thing, and you get the vested rights. And what you need to file, as I said, is pretty minimal. You need 9 non-binding site plans and elevations, which can change as long as the square footage and the density don't change by more than 20%. And then once you have submitted that preliminary application, you have 180 days to file the full application. So again, there's no role for local governments here. Now, how this fits in with the builder's remedy is, the idea is you file your SB 330 preliminary application while the jurisdiction is out of compliance. And then even if the jurisdiction later gets into compliance, under SB 330, the zoning standards are frozen at the point in time when you filed the preliminary application. So it doesn't matter that the jurisdiction got compliant later. What matters is it wasn't compliant when you filed the preliminary application, and you have the right to proceed under the standards that were in place at that time. So this is why you want to file your SB 330 application while the city is out of compliance, to freeze the standards in place at that time. Okay, that's the theory anyway. There are still some questions. As I said, SB 330 is a new law. Builder's remedy is an untested law. So will jurisdictions be able to use sort of subsequent compliance to say, well, we should apply the standard retroactively? Maybe, but you know, of course, applicants are going to argue, and I would argue under SB 330, that whatever standards were in place at the time the SB 330 was filed, those are the standards the jurisdiction is held to. And so if the builder's remedy was in place at that time, then the applicant has the right to proceed under the builder's remedy. Okay, update here on this point. Again, not really many court decisions. There is one trial court decision from Los Angeles sort of affirming the sort of validity of the SB 330 process in general, but not in the context of a builder's remedy application. But this update has to do more with local governments scheming their way around SB 330. And this is always a theme in land use regulation, where the state tries to preempt certain things to make local governments process housing faster or at all. And local governments come up with creative ways to try to get around it. So a couple of things that we're seeing here. One is local governments weighing in and telling you that your preliminary application is incomplete, essentially sending you an incompleteness letter the same way they do under the Permit Streamlining Act. But remember, they're not allowed to do that. There is no role under SB 330 for local governments to send an incompleteness letter. But that doesn't stop them from trying. This is another area where if this sort of thing were to happen to you, this is something you want to discuss with the land use attorney regarding what the right response should be if you get an incompleteness letter from the city. They're not supposed to be sending incompleteness letters. The other sort of game that cities are trying to play is SB 330 requires, in addition to all of these standards being met, that you also have to pay the permit processing fee. So jurisdictions are either telling people they haven't paid the fee or trying to charge them a crazy fee. Like in one case in Northern California, I think they tried to charge the developer a $50,000 fee, and he's now fighting that, and that might become the subject of litigation. But again, that's not permitted. You can only charge the normal permit processing fee. So certainly one thing I would recommend that applicants do in consultation with an attorney is when you submit that preliminary application, you do it with a cover letter that includes whatever the permit processing fee is, and make sure you say something along the lines of, you know, we are submitting our fee with the application pursuant to SB 330, and this is sufficient to vest the rights under SB 330, so that it's made abundantly clear that you're setting down this marker that you believe you've paid the fee. But again, that requires some strategizing depending on the city's approach and what you think the city's approach is. But you definitely want to be careful about making sure the fee is paid and that the city isn't going to be trying to play any games with regard to the fees on the SB 330 application. Okay. Risks involved and tips on how to navigate them. Okay, again, this hasn't really changed from last time. Lots of unknowns as the builder's remedy statute is untested. CEQA is probably the biggest question mark still out there. The builder's remedy law and the HAA generally do not provide a CEQA exemption. And so there are questions about, again, game playing from the city if they can indefinitely delay a project that they know they cannot deny, right? So for example, they know that they can't deny your builder's remedy project. So they say instead, we're not going to deny your project. We're going to make you do another year of environmental reviews or another 2 years and hope that the delay will be enough to kill the project. There was unfortunately a recent trial court decision. Trial court decisions aren't precedential, that at least suggested that cities could kind of delay things indefinitely using CEQA. but and this is also update, right? But there are some signs to the contrary. So, for example, I'm sure most people on this call are familiar with the ongoing battle between the state and the city of Huntington Beach. One of those many battles is about the builder's remedy statute, in which the city has declared that the builder's remedy is simply not applicable in Huntington Beach. And one of the grounds they've cited is CEQA. Well, what's interesting, again, reading the tea leaves, is the Attorney General responded to Huntington Beach and said, we don't think you can use CEQA in bad faith to prevent the processing of builder's remedy applications. What that tells us is the AG, at least, is not going to sit by and permit municipalities to use CEQA as a bad faith mechanism for getting around compliance with builder's remedy. And that is really significant because the courts give a lot of deference to the Attorney General, just as they do to HCD. So if the Attorney General intervenes in a case or litigates a case where this question comes up, and the Attorney General takes the position that CEQA can't be used this way, there's a good chance that courts are going to be deferential. So I'm a little bit more optimistic about the builder's remedy being able to survive CEQA than maybe I was when I last gave this presentation. Second, as I mentioned, the statute requires substantial compliance. As I said earlier, that doesn't necessarily mean full compliance. It's not 100% clear if HCD's determination as to compliance is binding. As I said, though, there is that Martinez case that suggests courts will be quite deferential to HCD on the question of substantial compliance. Also, another question is the applicability of the builder's remedy in the coastal zone. The HAA says in this very cryptic language that it's not designed to lessen the impact of the Coastal Zone Act, but doesn't really describe what that means. So I might come back to that in just a moment. Those, I think, are kind of the big questions still out there about builder's remedy. There's a few others, but those are the big ones. And again, we're starting to see some hints of some answers, but nothing really definitive yet. Okay. On the plus side, given some risks, the HAA is an extremely pro-housing statute. The statute says that it must be interpreted and implemented in a manner to afford the fullest possible weight to the interest and approval and provision of housing. The burden of proof is on the city. The applicant or a third-party housing organization is entitled to reasonable attorney's fees if they win. And all of these are reasons why courts are supposed to resolve doubts in favor of housing. And we're seeing, at least again, indications that courts, as well as the state legislature, are starting to understand the trade-offs involved between housing and some of these other concerns, environmental concerns, labor concerns, and so on, and realizing that in striking that balance, housing needs to be weighted more heavily. So that's certainly, I think, a positive indication. And all of this, I think, to me, is a helpful sign when it comes to the builder's remedy relationship with CEQA, Coastal Zone Act, et cetera. Because again, if ever there's a conflict between these laws, again, the HAA is supposed to be an extremely pro-housing statute. The whole idea, as you can see in the very extensive findings of fact at the beginning of the law, are that that we have a housing crisis, and this statute is designed to help alleviate that. So to the extent there's a need to navigate between CEQA, the coastal zone, and the HAA, the courts are really supposed to be doing that in a way that puts a thumb on the scale in favor of housing. And that's going to be, I think, how we see the arguments develop as this gets litigated, which I think eventually it will. Okay, so again, how to navigate some of these risks that we've discussed. Consult a land use attorney. I think that's a pretty consistent theme. In terms of dealing with the CEQA issues, try to find sites that qualify for a CEQA exemption. Now, here's the thing about that. As you probably know, even if your site clearly qualifies for a CEQA exemption, jurisdictions aren't required to actually provide it. And so if you have a jurisdiction that's acting in bad faith, they could say, oh, no, you don't qualify for an exemption. We need to send you for another year of environmental review. That is a risk. But the more likely that your site qualifies for a CEQA exemption, the better position you're going to be in trying to get leverage with the city if you end up having to litigate, to have a favorable litigation with the courts, and also to get HCD and the Attorney General on your side. If it's a clear case where you qualify for an exemption, then I think it's more likely that, again, HCD, the Attorney General, and the courts are going to be on your side and make it difficult for jurisdictions to use CEQA in a bad faith way. So consider sites that qualify for a CEQA exemption. Update on this point. There is some disagreement among lawyers who deal with the builder's remedy about the Class 32 infill exemption. There are some who think that the infill exemption doesn't apply to builder's remedy projects because the infill exemption says you have to meet all local zoning and general plan requirements. But I think that's wrong, because what the Class 32 infill exemption actually says is that you have to comply with all applicable zoning and general plan standards, and the builder's remedy renders many of these standards inapplicable if the jurisdiction does not have a compliant housing element. So I think the better side of the argument is that the builder's remedy does apply to Class 32 infill exemptions. Of course, there are other exemptions as well. I know some attorneys are relying on the sort of sustainable communities exemption, but I feel like that's a little bit more esoteric and kind of difficult to comply with than the infill exemption. So there are kind of trade-offs, but definitely consider, along with your attorney, sites that potentially qualify for a CEQA exemption. Similarly, avoid projects with significant environmental impact. Same idea here. You want to try to get courts, the attorney general, et cetera, to agree with you that the project should be processed under the builder's remedy, and CEQA shouldn't be an obstacle. If the project has relatively insignificant environmental impacts, then you're going to be in a better position to make that argument. So definitely think about that. Here, fewer local regulatory constraints means lower risk. What I mean is, if you're only asking the jurisdiction to throw out 1 or 2 development standards as opposed to 10, now keep in mind, under the builder's remedy, you could ask for whatever you want. In theory, you could throw out the entire zoning code and say you want to build a 100-story building on a site that's zoned for 16-foot tall homes. Theoretically, you could do that under the language of the builder's remedy statute. But the more you want to deviate from the local zoning code, local general plan, the more resistance you're going to face from local government, the more likely they're going to try to find a basis in CEQA or someplace else to fight you. If you're only asking for 1 or 2 exemptions from the statute, something more similar to what you might request under the density bonus law, then the jurisdiction really has to do more of a sort of risk benefit analysis. Like, do we really want to fight on this if we're only being asked to waive a couple of things and we don't know how the litigation is going to come out, right? So try to think about fewer, requesting fewer exemptions from local constraints if you can. Finally, this one might seem obvious, but I think this is an interesting one. Consider jurisdictions where elected officials will support the project. Well, if they'll support, you'll think, well, if they'll support the project, what do I need builder's remedy for? Well, the reason is, sometimes you have a project, and I'm sure that many of you have seen this, I've certainly seen it, where the electeds like the project, but neighbors hate it, right? And the electeds want to figure out a way to help, but they don't, how are we supposed to get around these voters? Well, builder's remedy can help. If the jurisdiction is willing to help you on the CEQA part of things, then, and approve the project through the normal channels, it will then be harder for the voters to overturn the approval. My view is that a builder's remedy project is not referendable. So if the electeds approve a builder's remedy project, the voters can't overturn it for a referendum. At the very least, it helps provide local electeds with some cover with voters that they can say, look, I'm with you, I don't like this project either, but the Sacramento's saying we have to do this, so sorry. So this can help, I think, with those situations where you may have friendly electeds, but the voters are against it. Another thing I want to say here, and this relates to the sort of anecdote that Liz gave us at the very beginning. A lot of folks have been reluctant to use builder's remedy because they are worried about relationships with cities. But I think builder's remedy can actually help build relationships with cities. Again, in situations where cities know they have obligations to provide housing, they know that they need the housing, but they don't know how to get around local opposition. being able to use the builder's remedy is a way of helping electeds, again, point the finger at Sacramento and say, look, we're with you, but Sacramento's saying we have to approve this. So I think it can actually help build a relationship with a local government if it can be presented to them in a way that isn't necessarily adversarial. And I think it can be done that way. Of course, it is also useful in situations where you have a jurisdiction that's very hostile, where you're like, well, they're never going to process my project unless I can threaten them with the builder's remedy. So I think there's a way you can use builder's remedy with friendly jurisdictions, and there's a way, of course, that you can use it with hostile jurisdictions. But that's a question of strategy. And I think, and in some ways, of course, the best way of using builder's remedy is as kind of an implicit threat, where you say, look, I don't want to use builder's remedy. I've got this project. I'm complying with all your local rules. All I want is my project processed. Please process it. And just so you know, I mean, if for some reason you didn't process my project, I always have the option of using this builder's remedy thing and building something that's twice as dense, right? So it can kind of be there as this kind of shadow alternative. And again, a way for electeds to say to the voters, look, I know you don't like the project, but do you want to see something even worse there? Because if we say no to this one, the developer is going to come back with a project twice as dense, and under the builder's remedy, we're not going to be able to say no. So these are all interesting strategic questions that in the builder's remedy opens up the possibility of using some of these options. Okay, here are some good resources on the builder's remedy. Unfortunately, HCD has not given us a formal sort of technical advisory memo specific on the builder's remedy. There is one on the HAA that is, relevant somewhat to the builder's remedy because the builder's remedy is part of the HAA, but doesn't answer a lot of these questions. So at least for now, we're still kind of on our own. But here are some good resources to look at if you want to learn more about the builder's remedy. And of course, feel free to email me or call me for any additional information. Okay, I think that's what I've got. I'm happy to answer any questions. Liz, I'll let you sort of handle the Q&A. I think that makes sense.
Yeah, that's no problem. I've been tucking answers in the chat as I've been able to, but we actually just got our first one that I don't dare weigh in on, so I'll kick it to you. How is the builder's remedy affected by the Coastal Commission, or just being coastal?
Well, the Coastal Zone Act. Yeah, I mean, I think I mentioned that a bit earlier. Again, we don't totally know the answer to that. The HAA says that its provisions are subject to the Coastal Zone Act. Oh, and I'm sorry, I said I was going to address this in more detail, and I didn't. So my view is, again, if you take the HAA at its word, and its word is that the law is supposed to be interpreted to give the fullest possible weight to the provision of housing, then it cannot be that the HAA is totally inapplicable in the coastal zone, because that would be the implication here, is that, all right, if we're reading that language, that the HAA is subject to the Coastal Zone Act to mean the HAA doesn't apply in the coastal zone, then what we're saying is that all of the areas in the entire state that have the most severe housing crisis and the most severe housing demand are totally off limits for this law that is intended to address our housing crisis. And the statutory language specifically says it has to be interpreted to give the maximum weight to the provision of housing. So again, there's no case law on this. We don't have legislation clarifying the relationship between the HAA and the Coastal Zone Act. There is, incidentally, a statute that's designed to clarify the relationship between the density bonus law and the Coastal Zone Act that literally just says these two laws have to be harmonized, but doesn't say how. Right? So all of these questions are going to have to be answered either with more detailed legislation, with more detailed guidance from the state agency, or it's going to be decided by the courts, and it's going to have to be, applicants, nonprofit groups like People for Housing, and land use lawyers, making their best arguments for what we think these laws mean and what we think these laws were intended to do. And my argument is going to be, this law is intended to provide housing, the maximum amount of housing, and it can't be the case that the whole coastal zone is off limits. That would be an absurd reading of the statute. But there's nothing definitive about that. That's right. That's how the argument, I think, would go. And I think it's a good argument, but we don't know if it's a winning argument just yet.
We got another question. Do cities that still don't have an adopted compliant housing element need to complete all of their rezoning before they are back into compliance? My
Yes, that's
understanding
my,
was
yeah,
yes.
that's my understanding as well. I don't have the
Yes.
statutory site on that on hand, but there is a statute that says that if the cities have not completed their, do not have a compliant housing element by the deadline, and in fact, many of them were given an
Yeah,
extra year to do it.
right,
If they don't do it within 1 year of the deadline, which also has already passed, then they
right,
have to complete all the rezonings that they committed to in the housing element before they can get into compliance, which means for most of these jurisdictions, it's going to be a while before they're in compliance. Because as many of you know, to do a rezoning often takes, a year or more because you have to go
right.
through the whole CEQA process and everything and all the public participation. So that's why I think if your jurisdiction is out of compliance right now and does not have its element being actively reviewed by HCD, then now is a good time to be getting your SB 330 preliminary application in. And there's no reason to wait a whole lot of time because remember, the SB 330 application does not need to be super detailed and it can change right up to 20% in either direction. So you probably do have a little bit of time if the jurisdiction's out of compliance right now because they have to do the rezoning. But I don't like to wait. I always like to do things early rather than late, just in case something unexpected happens, like HCD surprisingly finds a jurisdiction to be in compliance.
So you were talking before about, developers that might have submitted a project that a city won't process for whatever reason, and you can use a builder's remedy almost as a cudgel to kind of encourage them to go ahead and, process the project you really want to do. This question is, can you file two builder's remedy or SB 330 projects at the same time? One more low key and one more I guess, intense to enable the city to opt for, quote, the lesser of two evils, unquote.
Yeah, I mean, I've been asked that question before, and it's a very interesting question. I'm not sure there's no clear answer on this. I would be wary about doing it because I think a municipality would say, well, whichever, you can only have one application for a site at a time. And I mean, especially if it's in the local municipal code, which it might be. And then most likely they're going to say your most recent application is controlling. There may be a way to strategize around that. Like, for example, maybe you propose a project with alternatives as one proposal, but you have to be careful about how that's done. But I think that's an interesting strategy, but a risky one to try to have multiple SB 330 applications live at the same time on the same site.
Yeah, because then it gives you can start asking the question, well, are people just spamming us, right? Are they just sending us? So here's a good question, which I think might be a great, well, depending on how long it takes to answer, might be a good last question. So this is something I have heard from my developer friends in the world, which is basically that to justify the risk of a builder's remedy project, the returns need to be very high, the price of risk. In order for the returns to be very high, the project needs to be potentially very out of character with the zoning of the neighborhood. Taking everything into consideration, the courts, the neighborhood opposition, CEQA risk, everything. How likely is a project that is extremely out of character with the surrounding area? How likely is it to get approved at the end of the day? And it says, we're talking about a high rise in a 3-story neighborhood. Is it realistic to believe that something like that would actually get built, or is it a pipe dream?
I mean, that's really, really difficult to answer in the abstract. It depends on the city, it depends on the neighbors. And also, are we asking about whether the city will approve the project or whether the court will overturn a denial by the city? If we're asking whether the city will approve it, I think certainly any high cost city in California that you need to use the builder's remedy because they're not processing your project under their normal development rules is probably not going to love a high-rise building in a 3-story neighborhood, which means you're probably going to have to go to court if they deny the project. Now, again, this is a situation where it's possible that you propose a more modest project and tell them, if you don't approve this one, we've got a more lavish one waiting in the wings that we can do under the builder's remedy. And then a lot depends on the city attorney, on the city staff, and how risk averse they are. right? In some cases, they may, depending, in some cases, they may say, well, yeah, this building is really out of character with our city, but we don't want to get sued by the, and lose a lot of money litigating the builder's remedy, because of course, a successful plaintiff can also get attorney's fees under the HAA. But other cities, like Beverly Hills or something, would probably say, well, we'll spend however much money we need. We're not going to allow this monstrosity in our single family neighborhood. That, it requires kind of a sensitivity to what you think about the politics of the jurisdiction and what kind of appetite you have for litigating if you're facing a denial. But it's definitely, that's definitely an issue. I think where the builder's remedy could be useful is where a city has, a very high cost city has very restrictive zoning regulations, and you can use builder's remedy to build a project that is modest, but still exceeding the city's land use regulations. High rise in a three-story in a three-story neighborhood is going to be a tough sell, but the point of the builder's remedy is that you shouldn't have to sell it to the city, right? So you have to decide: do you want to sell it to them, or do you want to threaten to fight with them on it?
All right. Last question I think we'll take is from our friend Jeff Collins. Shout out to you, Jeff. He wants to know, and again, this is outside of Orange County, but I bet you'll know, Ken, what is the city of LA's reason for requiring a builder's remedy project to go through zone change and general plan amendment as part of a normal entitlement process?
Well, I don't know that they can. Let me think about that for a second. I
heard that they just are off their rocker. That's what came through the YIMBY, I guess you could say, game of telephone, perhaps, was that they were just nuts, that this wasn't gonna fly. But
yeah, I could see a city saying, well, if we're going to process this, we have to put it through the normal channels, because we need to have public participation if we're doing what is essentially a zoning change, and follow the normal process that we normally follow. In other words, we know we can't deny your project, but that doesn't mean we can't go through our normal process to make sure that the public opinion is adequately heard about it. The builder's remedy statute doesn't say specifically that a municipality can't make you go through a sort of quasi rezoning process. All that it says is they can't say no, right? And they can't condition the project in a way that makes it infeasible. So I guess in theory, they could make you go through whatever the normal process would be for a rezoning. They just couldn't, they couldn't at that point deny the project.
okay.
But that's a really interesting question. There are some situations, for example, where the project is plan compliant, where the statute says that the municipality cannot require a zoning change. But now we're talking about a situation where the project is neither plan compliant nor zoning compliant, and you're using builder's remedy to get around both. So I think there is a little bit of statutory ambiguity there about what the city can do. But that's an interesting one.
Awesome. All right. Well, I think we're going to end it there so folks can, get a break before they're probably off to their 1 o'clock. I will make a plug for People for Housing if this has been useful to you, and if you feel that our educational programming is beneficial, we would invite you to support our work. You can donate on our website at https://peopleforhousing.org. We have a brand new website. It's just come up in the last 48 hours, so you can go there and check us out. We'd really appreciate it. And yeah, I think that will end it there, and really appreciate your time, Ken, and your partnership over all these years, and hope everybody has a great afternoon.
Yes,
bye,
me as
everybody.
Well. Thank you.
Oh, it says put the website in the chat. Okay, I will do that so that you can support our work. All right. Thanks, everybody.
Thank you.